that they were willing to do from the very beginning. Now, we have a big lineup of guests today. I think we've got Alan Honner from the Democracy Fund, who is sitting, I think, directly adjacent to you in the Airbnb studio. Hey, Alan, good to see you. You were questioning the cabinet ministers today. Why don't we go to Alan's clip and then let's talk to Alan. She's not ready. You know what, Alan, you had some text messages. No, are we good? Okay, Alan, you had some text messages that came out in your examination. Why don't you tell us what those were all about?
Right. So Sheila, in my examination of David Lametti, what I wanted to explore was when Cabinet and the Prime Minister decided to invoke the Emergencies Act. And we know under the Emergencies Act that they have to consult with the provinces. And so what we did is we took them through a timeline. We saw an email, and that email was from the Prime Minister's office, and it was suggesting that there was going to be a press conference on February the 14th, and that it was to be kept quiet until after the first ministers' meeting. So we just wanted to explore that and see why it was supposed to be quiet, and whether or not the Prime Minister and Cabinet had made up their minds beforehand. And one of the text messages that we brought the Minister of Justice to was a text message from the 13th, in which he was having a conversation with an MP, I believe, in the sort of Ottawa area, and that text message concluded with a summary of a conversation in which they said that there's a consensus to invoke the Emergencies Act. Now, in fairness,
and so it didn't matter what the First Minister said. Well, that was theater.
Well, you know, I can't say for sure, right? But we just wanted to put it to him and explore it. And so, you know, there's been evidence both ways, but part of the process or part of the purpose of the inquiry is to test this evidence.
And we also have, I think, a second clip of you, Alan, questioning Minister Justice Lametti about text messages and the lengths at which the Government of Canada would go to keep the Emergencies Act in effect. And it seemed as though they were willing to keep it in effect insofar as the NDP and the senators would support them, and they would, you know, sort of repeal the use of the Emergencies Act when they felt as though they were losing the support of the NDP. So it really wasn't about public safety at all. It was about how much they could do and how long they could do it for until it became a political hot potato for them.
Right. So, Sheila, so what we saw was that there was a text message between MP Greg Fergus and the Minister of Justice on February 23rd. That was the date that the Emergencies Act was revoked. And it was and the message suggested that perhaps the federal government wanted to stay ahead of the NDP, and they wanted to revoke the act before the Senate could vote on it. And there was some contrary evidence later on in the proceeding, but the question still remains: if the NDP withdrawing their support wasn't a concern, then why bring it up? And if the Senate voting against the Emergencies Act wasn't a concern, then why talk about that in a text message?
Olivia, did you find that clip?
This is another email exchange between you and Greg Fergus. And he says, on February 23rd, I am glad we ended the EA, but it would have been more appropriate if we waited until Friday. 44 hours after the vote seems unseemly. And your response is, no, we needed to stay ahead of the NDP, and the senators were saying that they would vote against, based on their view that there was no longer an emergency. That is your text message with Mr. Fergus?
It is indeed, and although we did have the votes, and although the vast majority of senators understood that they were being asked to vote on the Emergencies Act at the time at which it was invoked. There were a number that didn't understand that. We had said from the beginning, sir, that we would not keep the act a minute longer than we needed to. It's something we said to the NDP, and it's something that we said to senators. And I'm being completely consistent here to say that we needed to be ahead of that in terms of keeping our promise in order to not keep the act in place a minute longer than necessary, and that's precisely what we did.
And this is my last question. I put it to you that this text message shows that, in fact, you would have kept the Emergencies Act in place for longer had it not been for the fact that you were concerned that the NDP would withdraw their support and that the senators would vote against.
I reject that premise. There are other text messages that you will see where we have predicted that we had sufficient votes.
We'll leave that to submissions. Thank you very much, Minister.
Thank you.
Sure sounds to me like he would only keep the Emergencies Act in place as long as he could get away with it politically.
Well, we'll never know what would have happened with that Senate vote, will we?
No, we won't. But I think he does. I think David Lametti does. Now, I want to talk to you a little bit about some of the other questions, I guess, from the Freedom side. Olivia, you want to cue up clip 4? David Lametti refuses to answer Freedom Convoy lawyer Brendan Miller's question about the broader scope of Section 2 of the Emergencies Act. Lametti kept citing hiding behind solicitor-client privilege. But this is one thing that's really come out in the final days of the commission. I think it was probably universally understood at the beginning of this that to invoke the Emergencies Act, the convoy had to reach the bar of Section 2 of the CSIS Act, one of those 4 provisions there. But then all of a sudden, when police forces kept saying, no, it didn't meet that, then we've said, okay, well, not we, but the Liberals, it is their contention that it's actually much broader under the Emergencies Act. And really, this is in only the final weeks of this thing have we even ever heard that. Before it was, yes, definitely, police forces asked us repeatedly that they needed these extra tools. And only when police forces started testifying that they didn't, they sort of changed whatever the argument would be. And they said, well, actually, that's not even the requirement under the Emergencies Act. Am I reading that right? I'm not a lawyer, but you are.
Well, Sheila, I think you've sort of zeroed in on what has been a major frustration for many people who are watching the emergencies, the commission, as well as some of the lawyers, because what we really want to get to is this question of, well, why did you invoke the act? And to know that, we have to know a little bit more about what was discussed in cabinet, and we really need to know what advice David Lametti gave to the other cabinet members. But as you saw, that information is privileged. So there's solicitor-client privilege, that's in play, and there's cabinet privilege, and that's in play as well. So there's a double layer of privilege here. And in some ways, sometimes there might also be a third level of privilege, national security confidentiality. So there could be potentially 3 levels of privilege, but it is frustrating. And, when I think of it, I think it makes perfect sense that the government would not want to waive national security privilege. There's a very good reason why that exists. And generally, there's also a very good reason why cabinet privilege exists. And also for solicitor-client privilege, but solicitor-client privilege can be waived, right? And we saw at the beginning of this inquiry that the government was congratulating itself on its historical waiver of privilege, but when it really gets to the meat of things, we don't know what happened.
No, and we can piece together the timeline of some of the conversations, and you can infer certain things from the timeline and the things that happened after certain conversations. For example, we had the director of CSIS, David Vigneault, say repeatedly, this convoy did not rise to meet Section 2 of the CSIS Act. It's in briefing notes, I believe, to cabinet on February 10th, where he's saying no plots of sedition, no, nothing. This is not a national security threat. It's a little inconvenient, but that's about it. And then between the 10th and the 13th, he meets with David Lametti's Justice Ministry and for outside legal advice, but that hardly seems outside to me when you're meeting with the Justice Ministry that wants to invoke the Emergencies Act. And we've seen the government say that from as early as, I think, January 30th, David Lametti did. But, so he meets with the Justice Ministry, and then by the 13th, his opinion on what is the scope and scale of the Emergencies Act and what constitutes a security threat there has changed from what everybody knew was in the act before. And then he advises Justin Trudeau, yeah, you know what, go ahead and invoke the act. So again, I'm curious, what advice is the Justice Ministry giving out? And they won't really reveal any of that. They're saying it's, as you say, solicitor-client privilege, but that's the crux of all of this, is what advice did you give to these people that led them to believe that they didn't need to meet Section 2?
And you're absolutely right, Sheila, and we're just going to have to resolve this inquiry without knowing that advice. We've heard some evidence, from different people. We've heard evidence from the clerk of the Privy Council. We've heard evidence from the National Security Intelligence Advisor, and we know what their interpretation of the test was. And I think a lot of us were quite puzzled when we heard that, because it doesn't seem it doesn't seem to accord with the obvious reading of the legislation, and this might have to come down to legal submissions. And in some way, I think I'm just in a way I'm thinking out loud here. If the government is not going to say what advice was given, then they will have to live with that in their legal submission, in their final submissions as well.
Yeah.
And so it'll come down to a legal argument.
And that, that's hardly the point of all of this, because this is a public inquiry. So the public has some interest in finding out these things for themselves. Let's go to clip 4. So we can see this invoking of solicitor-client privilege in the face of prickly questions in real time.
Narrow it down. Was there any such document that you reviewed in preparing for your testimony here today that existed prior to the invocation of the Emergencies Act, that it was discussed, that isn't subject to solicitor-client privilege, that it was discussed that there was a broader scope of Section 2 as it applied in the Evidence Act?
Once again, that's a question that's asking me to effectively divulge legal arguments. I remind my learned friend that it is very odd to put a lawyer on the stand. I'm really here as a cabinet minister in order to speak to facts.
I know.
And it is to some extent an obligation for me to try to answer questions as best I can. But right. You're asking me to answer questions as a lawyer, and it would be remarkable to put a lawyer up on the stand in the middle of the case. I
understand, sir. And so again, I would like the question answered. Did you see any documents that talked about this interpretation that you're discussing that existed prior to the invocation of the Emergencies Act?
Again, I'm going to rely on solicitor-client privilege there.
I don't know. Keith Wilson testified. He's a lawyer.
That's right. So Sheila, I think we do have to be a little bit fair to the Minister of Justice here. If something is really privileged, then he can't talk about it, and it's not up to him to waive it. But I'd like to return to something you said earlier, because you said, well, the point of this commission is to get to the truth of what happened. And this just goes back to the nature of privilege, and privilege always exists in tension with finding the truth, right? And it's usually because there's some type of relationship that you want to protect. That relationship might be the relationship between a lawyer and a client, or it might be the relationship between say, a church member and a priest, right? Or it might be the relationship between a husband and wife, and there are all sorts of privileges, but they sort of, in some way, they frustrate the truth or the search for the truth, but that's part of our legal system. Now, I think we mentioned this before. Oftentimes, privilege can be waived, and in this case, solicitor-client privilege was not waived.
Yeah. Yes. It's very frustrating. It's very frustrating as a member of the public. I understand why it exists. But Justin Trudeau assured me way back in 2015, this is the most open and transparent government that I would ever be exposed to in my entire lifetime. And I'm still waiting to see it.
I think we'll all have to make up our minds about that one.
What I want to ask you while I have you and before I let you go, because I know we've got another lawyer standing there waiting to come on the show. What do you expect from the rest of the week?
Well, we have three more witnesses. Tomorrow we'll hear from Chrystia Freeland. We'll hear from a panel from the Prime Minister's office. And then we'll finally hear from the Prime Minister. I don't think we're going to hear anything new. I think we're going to hear, more of the same testimony. But there might be a few surprises here and there. There will be some contesting of their evidence. To some extent, I'm a little constrained here, Sheila, because
I know
we see things before the public sees them, but we can't talk about them. And of course, we have questions that we plan to ask, but we won't put those on. We won't put those on live television or on live stream the day before we're asking those questions.
Yeah, you don't want to give the bad guys any heads up. But also, I'm not convinced that you're getting to see things well in advance of the public based on how the federal government is releasing documents to you guys as the witnesses are testifying.
Some of that has come out in the public order emergency inquiry. You're right. So there's been some discussion already about how documents are released late, and this is part of the. It can be difficult to keep up when that happens. Absolutely.
Oh, you're so diplomatic, Alan. Alan, thanks so much for coming on the show, and thanks so much for your hard work at the commission. Let's cut to an ad, Olivia, so that we can let Alan leave the set without a tangle of headphones and